Mr. Speaker, we agreed that while the role of Parliament is restricted, it is not ceremonial. It is not ceremonial because if you look at Article 94(1) and 94(3), you will see that Parliament is the sieve through which anything that becomes law in this country must come. Parliament is restricted when it's popular initiative, but it is not ceremonial. And I will explain that a little more. Mr. Speaker, Parliament cannot substitute its views for the views of the promoters. And therefore, Parliament cannot make any substantive change to a document that has come through popular initiative. But, Mr. Speaker, Parliament, on a close reading of Article 94(1) and 3, has that inherent authority to make any errors, to correct any errors of form or typo which are consistent with the intention of the promoters, which does not substitute the intention of the promoters. So if the promoter meant Article 89(7) and it reads 87(7), which does not exist, Parliament can, in its discretion, correct that. But as to whether we choose or not, that is for us. And it depends on whether that typo has any grave legal consequences. And as I'll show later, in our case, it doesn't. Mr. Speaker, we agreed unanimously that in this process, a referendum is a must. And this document must be taken to the people in a referendum. That is agreed. Mr. Speaker, we also agreed that public participation is not perfunctory. It is not salutary. It is substantive. It is substantive first because it is a constitutional requirement. If we do not do it, then the process is in danger of nullification. It is also necessary, Mr. Speaker, because it helps us identify some of those gaps and how to deal with them, as we have. But more importantly also, it helps us make up our mind whether we want to vote yes or no. We did examine some very specific issues which have been raised as unconstitutional. One is the question of the Judiciary Ombudsman. Two is the question of removal of vetting of ministers and PSS. Three is the question of regulation of professional fees. And four is the question of the manner in which the two-thirds gender principle has been put in the Constitution. I'm happy to tell you, Mr. Speaker, and this House, that after thorough examination, and you'll see that in the report, and even after engagement with the experts we had engaged with, we came to a unanimous conclusion that none of those provisions are unconstitutional. Some people might find them undesirable, but undesirability and constitutionality are two different things. As long as it's constitutional, if the people agree with it, then it is okay. Mr. Speaker, I want to say this, and I want to say it categorically, and this is where the one issue arises: constitutionality. Mr. Speaker, as a matter of law, and this is where I disagree with my chairman, a constitutional amendment can be unconstitutional in two ways. It can be unconstitutional if it does not follow the process that is already in the current constitution before it's amended. Or it can be unconstitutional because it results in something that does not accord with constitutionalism. Mr. Speaker, if today there was a popular initiative that suggests that we must exterminate one of the 43 ethnicities in this country, as happened in the Holocaust and elsewhere, it would be unconstitutional, even if it came through this House and was adopted, because in substance it's unconstitutional. Or in this House, if today we decided that the presidency will only rotate in one ethnic group, it would result in that. I'm not speaking to the document yet, I'm speaking to the theory. Constitutional scholars agree that you can have a constitutional amendment that is unconstitutional. Now, what we have done, and professors of law like John Buddy is saying it's not true, but that is okay, because that is your view. I am talking about the law. John Buddy, you've not stepped in law school, so just allow me. Now, the thing In our case, there were issues that were raised. In our case, there were issues that were raised about fairness of Schedule 2. There were issues that were raised about constitutionality. There were issues that were raised about completeness. I will not speak to them because they're in the document. But to be fair, because there are equally members, including lawyers, who do not agree with me, and they're entitled, because in law, there's no strict answer to anything. There are lawyers who believe that no constitutional amendment can be unconstitutional. What we have done, Mr. Speaker, and that was the midway path, we put the view on constitutionality and the view on unconstitutionality. But what we didn't do, there was a serious push by some of the members of the committee to suggest that we sever Schedule 2 and remove it. That because Schedule 2 is part of the document, and we had agreed that we cannot make substantive changes to the document, it must go with the document. And therefore, what it has done is that it has given members of this House the opportunity to look at it and make up their mind. But what's important is, it is merely an observation. It has nothing to do with the document itself. For the document must go as it is. As I'm closing, Mr. Chairman, Mr. Speaker, and this is my last point, the minor errors. Mr. Speaker, I'll urge members to look at page 99 of the document, where we identify some of what we call minor errors and typos. Ultimately, Mr. Speaker, looking at that list, there is only one typo in the bill that we are considering, and that is in respect of Clause 51. Clause 51, Mr. Speaker, refers to Article 204. The only thing it does not do is indicate that it's looking at 204 sub-article 6. So we have two options. We can either exercise that jurisdiction here and just insert the word sub-article 6, or we can leave it. I want to submit, Mr. Speaker, that whether we exercise it or leave it is of not much consequence. Because even if we don't change it, the very Constitution that we have encourages a purposive interpretation of the Constitution. Anyone looking at this amendment will see that what was intended to be amended was Article 204(6). So even if we don't invoke that jurisdiction that we have for correcting typos, form and error, it is of no consequence. Because any interpretation, because it's very clear, because it talks of the sunset clause, in the entire 204, no other sub-article talks of the sunset clause. So I want to submit, Mr. Speaker, that it is perfectly in order to pass the document without any amendment, because any typo is inconsequential anyway. Mr. Speaker, with that, I want to go to the words as appearing the recommendation of the entire committee, which is unanimous on page 169, that having considered the Constitution of Kenya Amendment Bill 2020 and the submissions received, the joint committees recommend that the Constitution, that this National Assembly and the Senate pass and approve the bill. And in addition, which is the second one, that Parliament enacts legislation to provide a framework on the processing of a bill to amend the Constitution by popular initiative subsequently. The ultimate recommendation of this report is that both houses approve the bill without amendments. And that is in page 169. It is true that there are members who may have spoken prematurely on this, not knowing the conclusion of this report. The report does not recommend any amendments to any part, and I will explain. Mr. Speaker, we were unanimous on the 32 issues that the chairman has spoken to, except one on which there was a divergence of opinion, and what we did in good conscience was to include both shades of opinion, and they're both in the report. But Mr. Speaker, what we did is that in the course of these consultations, we did identify some minor typos, and I will speak in terms of how they are dealt with. It is the role of any committee that is tasked with such work to identify what could be pitfalls in the journey. That we did. If you are irresponsible, you ignore them, hoping no one will notice. And sometimes it has disastrous consequences. But if you are responsible, you identify them and see how to resolve them. If you read the entirety of this report, where we have identified pitfalls, we have suggested how you overcome them. Now, that is what some people misunderstand and think it is sabotaging the report and the process. That is actually facilitative, not disruptive. It is to protect this document from any possible flounder thereafter. Mr. Speaker, especially if one reads the report completely, you will see, and I will come back to this, that at the end, there are only 6 minor areas, and they're on page 99 of this report. Minor areas of typos. 2 of them, we decided that we cannot touch because they would require us to put ourselves in the place of the promoters. The other 4, in the bill before us, you will see that 3 of them are actually not in this bill. There's only 1, and I will speak to it, and it is quite minor. So I also want to let people know that there are no major issues in terms of inconsistencies or typos, as may have appeared. The fact that we identified them does not magnify them, and they're very easy to deal with. Mr. Speaker, I want to assure the nation and this House that the committee was unanimous on all 31 issues, and there was no division between the Senate and the National Assembly at all throughout our deliberations. And you will see in the signature page that it is signed across the board. Mr. Speaker, we were agreed, and even after consulting with the experts, that this is a popular initiative under Article 257. The question of who initiates it is irrelevant to whether it's popular or not, because we agreed that in all the countries where you have popular initiative, it is an additional measure. Constitutional amendments usually could be proposed by Parliament or by the executive. Popular initiative gives any other person the opportunity, but does not exclude the first 2. Even this Parliament can choose to initiate an amendment by popular initiative rather than inside this House. So the issue that the executive may have initiated does not take away from the fact that it's popular initiative.